To the contrary, no. The ayes have it.
Fair Trading Soliciting on behalf of Charities Amendment Bill, third reading.
Call on Members' Order of the Day number 2.
Register of Pecuniary Interests of Judges Bill, first reading. Mr Speaker.
I call Julianne Genter for Dr Kennedy Graham.
Tēnā koe, Mr Speaker. I move that the Register of Pecuniary Interests of Judges Bill be now read a first time. I nominate the Justice and Electoral Select Committee to consider the bill. Mr Speaker, before I speak to the substance of this bill, I would just like to quickly pay homage to the hard work put in by my colleague, Dr Kennedy Graham, on this bill. It is a fine piece of draft legislation and deserves careful consideration. Unfortunately, his global affairs portfolio responsibilities meant that he could not be here this week to speak to this bill.
Just a point.
Yes.
In the future, you can't refer to the absence of a member. I know in the context of this we understand,
Thank you,
but
Mr. Speaker.
Just think about it in the future. You can't talk about the absence of a member.
Given that the bill was introduced in November 2010, one would have hoped it could have reached this stage before now, but we are glad that it is finally here, and we acknowledge and appreciate that the government has agreed to work with us on this bill. We in the Green Party, and I believe pretty much the whole of the country, were saddened by the set of circumstances that led ultimately to the resignation of one of our most talented judges not very long ago. It is always a personal tragedy when unexpected events put to an abrupt end the work of talented individuals who have contributed much to the future of New Zealand. The circumstances surrounding that episode do not warrant detailed investigation here in this debate. Suffice it to say that it exposes a number of characteristics of the judiciary of a small country such as New Zealand, and perhaps of countries that are even not so small, the limited and to some extent intimate circle of acquaintances that go to make up the higher echelons of the judiciary. In such circumstances, there exists an even greater than usual responsibility on the part of all individuals involved to ensure that the integrity of the system is not in any way compromised through a strict respect for the principles of openness and transparency. It is a time-honoured principle of Western democracy that public servants of every kind must be beyond reproach. Public confidence in the standard of behaviour and conduct observed by leading servants of the people is a cornerstone of social harmony and political stability. A threshold of confidence should ideally be enshrined in constitutional and legislative form. Little scope should be available for individual discretion or subjective perception. The principles of transparency in this respect pertains in particular to issues of financial interest. Nothing undermines public confidence in a nation's institutions and procedures more than a suspicion that a public servant may have suffered a conflict of interest arising from a financial engagement in a particular dealing in which one was professionally involved. In New Zealand, members of the executive have been required, under statute since 1990, to provide statements of pecuniary interest pertaining to their personal financial affairs. Such statements are submitted to the Speaker, and these are made available for public consumption. In 2006, this practice was extended to all members of Parliament. Since then, MPs have been required to submit annual statements of pecuniary interests to a registrar who makes the information publicly available. The legislature's version of pecuniary interest statements was modelled along the lines of that of the executive. In both cases, a careful balance has been struck between transparent public knowledge of an individual's financial affairs and the preservation of personal privacy. The correct balance in this respect appears to have been achieved over the years. The public interest in such annual statements is significant without appearing inappropriate, and few complaints have been voiced by those on whom the obligations are placed. There seems to be general acceptance that such exercises are in the public interest and are neither unduly onerous nor revealing. No such practice, however, has been observed in the case of the judiciary. Recent developments within New Zealand's judicial conduct processes suggest that application of the same practice observed by the other two branches of government might assist in the protection of the judiciary in the future. Being obliged under law to declare pecuniary interests, that might be relevant to the conduct of a future case in which one is involved would relieve a judge from a repetitive weight of responsibility to make discretionary judgments about his or her personal affairs as each case arises. Having declared one's pecuniary interest once, in a generic manner, independent of any particular trial, a judge may freely proceed in the knowledge that if one is appointed to adjudicate, public confidence for participation has already been met. Yet care is to be exercised to ensure that the final decision is left to the individual judge whether to accept a case. There should be no intention of external interference into the self-regulation of the judiciary by the judiciary. Mr. Speaker, this is the reasoning behind the draft legislation before us. It takes as its purpose the promotion of due administration of justice by requiring judges to make returns of pecuniary interest to provide greater transparency within the judicial system and to avoid any conflict of interest in the judicial role. Let me review the main provisions of the bill. Clause 4 provides that nothing in the bill is to be interpreted as compromising the constitutional principle of judicial independence guaranteed by the Constitution Act 1986 and respected by constitutional convention. Clause 6 describes the two key components of the bill, which are to require returns of pecuniary interest from judges and to establish a register of such returns. Clauses 5, 7, and 8 impose a duty on judges to make an initial return of pecuniary interest following appointment as a judge. Clause 9 lists the contents of returns of pecuniary interest. Clause 14 provides that disclosure of the actual value, amount, or extent is not required in relation to any matter which is required to be disclosed. Clause 19 provides that the registrar must publish the information contained in both initial and annual returns of pecuniary interests. Clause 20 provides that the registrar must publish the name of any judge who fails to submit any return. Clause 21 provides that it is the responsibility of each judge to ensure that their obligations under the Act are fulfilled and places limits on the responsibilities of the registrar. Clause 22 provides that a complaint that a judge has failed to make a return of pecuniary interest is a matter which has bearing on the judicial functions or judicial duties of the purpose of the section 16.1 subsection B of the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004. Mr. Speaker, this bill is not designed to imply any right of the legislature to intervene in the affairs of the judiciary. As I said before, nothing in the draft would be interpreted as compromising the constitutional principle of judicial independence guaranteed in our Constitution. The intention of this bill is simply to facilitate the promotion of due administration of justice by requiring a similar financial return by judges as is already required by both the legislature and executive of this country. We submit that our constitutional integrity as a nation will be enhanced with the passage and adoption of this bill. Thank you.
The question is that the motion be agreed to. The Honourable Simon